This module is about contracts in real estate. A contract is a voluntary agreement between two or more parties. Each one of them must perform a certain act within the contract. Contracts in real estate in Massachusetts fall under what is called the statute of frauds. In order for a real estate contract between a seller and a buyer in real estate to be valid and enforceable in a court of law, it is required to be in writing. Massachusetts law calls the requirement for a real estate contract to be in writing the statute of frauds. Oral contracts are not valid or enforceable. In the brokerage, we discussed listing agreements and buyer agreements. Those are considered contracts in real estate. An important contract in real estate is known as offer to purchase. This is a legally binding contract under McCarthy v. Tobin. Once all of the parties involved in an offer agree to it with signatures and a binding down payment check, you now have a binding offer. The offer has several contingencies within the offer. Think of an offer as a summary of what a buyer will do for a seller if the seller agrees to sell them their home. You would put together a summary of, I will pay this amount of money, I will put a deposit down of this amount of money within the next 24 hours, I will put an additional deposit down after a home inspection, and I will close the deal on such and such a date. The seller will agree to or not agree to that offer. Once the offer is signed by all parties and a check for a deposit has been made, you now have that binding offer. How do you void an offer? Once the seller and the buyer and the check have been received, you cannot void your offer. Your buyer would have to relinquish the deposit that they made to the offer within the offer. So there is no withdrawal from any offer without losing your initial down payment. Your initial down payment is called earnest money. We call it all different things throughout the country: good faith money, binder money, earnest money, down payment. They are all something that is binding to the offer. Without that check, without a deposit, you have no binding or valid offer. Within any offer, time is of the essence. Once a buyer and seller have agreed on the offer, the dates within the offer are now required to be met. Within the offer, you'll have different contingencies. You'll have a mortgage or a financing contingency. I cannot purchase this home unless the bank loans me the money. That will protect the buyer's deposit, and the buyer will receive their deposit back if for some reason they were unable to get a mortgage. Inspection contingency is the next one. That allows the buyer to have lead paint, insects, overall condition of the property, radon, and any other inspections that they may deem necessary in order to proceed with the purchase of the home. In Massachusetts, it is required to give a buyer 10 days to have any and all inspections completed. Property sale contingency for a buyer. There are times when a buyer is purchasing a home but must sell their current home in order to do that. And there would be a property sale contingency for the buyer that says, I must sell my home in order to purchase this home. Or another term would be subject to the sale of my home at such and such a place in Plymouth. The buyer would have what is also known as a 48-hour kick-out clause, which will allow the seller to continue marketing the home and approach the buyer should they have an offer that is without a contingency, and give that buyer an additional 48 hours to decide whether or not they will be able to move forward with the purchase of their home, or they would have to cancel the agreement and receive their deposit back. Without this contingency, they would not receive their deposit back. A property sale contingency for a seller could be that the seller will need to find suitable housing for themselves before they can sell the home to you, the buyer. This allows the seller the opportunity to back out of the deal if they cannot find suitable housing. These contingencies have escape clauses, kick-out clauses, and other things known as backup offers. When you have these types of contingencies as a property sale contingency for a buyer or a property sale contingency for a seller, usually the property would stay on the market for additional backup offers. Amendments, changing a contract. When you amend something, you change it. So you're amending something that has already been prepared with either crossing it out, Xing it out, and each time you amend a contract, you must initial all of the changes made in that contract. Addendum, ADD, is adding additional documents to a contract. An addendum can change the contract between two parties by adding terms to a contract, thereby creating a revised agreement or a new agreement. It does not change the original content, and changes should always be dated and initialed by all of the parties. When you have a contract and you have addendums or exhibits attached, in order to be upheld in a court of law, you will want to write see attached addendum A, see attached exhibit B. Without that, a judge would be unable to determine whether or not that addendum was truly, in fact, a part of the original agreement. Purchase and sale agreements, the next most important document or contract in real estate. Once all of the offer terms have been met, the purchase and sale agreement is now a legal document that expands on the what's, where's, and why's of the offer. Think of your offer as a summary of information on a small piece of paper asking the seller to sell you their home for this amount of money and on these specific dates. Once everybody agrees to move forward after certain things are done, such as your home inspection or any other thing that is required within the offer, you move into that purchase and sale agreement. The purchase and sale agreement will lay out all of the legalities of, and if you don't do this, and if they don't do that, and what happens at this point in time, and what needs to be done by this date and that date. So it expands on every detail of the offer so that it is easily interpreted by a judge if necessary. If any seller or buyer signs any contract without reading it, they are still bound to those terms. No one will ever win in court by saying, I didn't read this contract. When the parties enter into a purchase and sale agreement, the buyer obtains what is known as equitable title. And then once the deed is delivered, the buyer has legal title to the property. Contract types, characteristics, and essentials. Valid contract. A valid contract has to have, by law, essential elements in that contract, making it a valid contract. Absent any one of the elements in the contract, your contract would become void or voidable. Here are some elements of a contract. Offer and acceptance. Offer and acceptance is known as meeting of the minds or mutual assent between the parties. The buyer agrees to purchase and the seller agrees to sell. Consideration In real estate, in order to have a valid contract, you must have consideration. There must be some valuable consideration. Products or services are also known as consideration. So in a purchase and sale agreement, you can have valuable, which is money, or goods, which is products and services. You can also have what's known as love and affection. Legal capacity. Parties who are involved in a transaction must be legally competent in order to conduct the transaction. Any individual who signs a contract while they are insane, intoxicated, or as a minor do have the ability to have that contract canceled, which is also known as making a valid contract voidable. Legality of agreement is the agreement cannot call for any of the parties to perform an illegal activity. If someone has an illegal activity and declined to perform that, that would not be a remedy in a court of law. What would be an illegal activity? One of the biggest things in Massachusetts, an illegal agreement would be renting property with lead paint to anyone who has a child under the age of 6. That doesn't mean you can exclude them from renting. That is a whole tenant landlord section that you can hear another module. But if you had a lease and that lease was renting to a family with children under the age of 6 and you had lead paint in your home, that would make that agreement illegal or void. Reality of consent is that you signed of your own free will. There was no duress, no fraud, no error, and the parties must have entered into a contract of their own free will. What is a void contract? A void contract would be the same contract I mentioned previously about a lease with a family and children under the age of 6 in a home with lead paint. That contract is void. It never was valid from the moment it was printing off the printer. So what is a voidable contract? Well, a voidable contract has all of the elements, has no illegal activity in it, but the person that signed it was a minor, or they were mentally incapable of signing it, and that could make a valid contract voidable. So it's not void, it's valid, but it has the opportunity of becoming void, known as a voidable contract. So what does that all mean? Let me explain. Take, for example, you have a parent who may have Alzheimer's. And you went to visit them and they told you how excited they were. They just sold the house for $50 so that they could pay the milkman. That would be cause for you to have that valid contract voided. You might say, well, isn't a $50 sale of a $1 million home illegal? No, it's not. You can sell your house for $1, love and affection if you want to, as long as there's consideration in there. There is no law stating how much consideration it should be. So that would make a valid contract voidable. You could take that to court and more likely than not win. However, if you went to that same parent and that parent told you that they just sold their house for $50 million and the house is barely worth $50, you have a valid contract and it is voidable. But again, you don't have to make it void. You can continue on and say, well, that's awesome. Let's retire. So you know the difference. Voidable means it's a valid contract that can be voided. Duress. Duress is when someone causes you to feel pressure or intimidates you into signing a document or doing something that you're not willing to do on your own. Fraud is when you're being misled. If you are being deliberately misled by an agent, by a buyer, by a seller, and you were not aware of those problems but found out later on, that is fraud. Misrepresentation of a property. There can be accidental misstatements about property, but anytime you are truly being told information or having information withheld from you, that is known as misrepresentation and cause for avoidable contract. Unilateral contract. So the contracts that I'm talking about where you have buyers and sellers signing, you have offers, purchase and sale agreements, those are known as bilateral contracts. Two parties, each party doing something in order for the other party to create this executed contract. A unilateral contract is one person committing to another, and only that one person. A unilateral contract in real estate is your MLS listing. When you list your property on MLS and you are telling all of the other agents within the MLS system that you will pay them 2.5%, 3% of the sale price of the property, you are creating a unilateral contract. Now, all of the other agents don't have to sell your property, but the one that does is the one that will receive the compensation. An example outside of real estate is someone putting up a sign that says, "I lost my cat, and if you find him, I will pay you $5,000. That is a unilateral contract. That is the person stating that they will pay you if you find the cat. You are under no obligation to find that cat. Option contracts are also unilateral contracts. What is an option contract? Lease with an option to buy is an option contract. Right of first refusal is considered an option contract. Option contracts generally hold the seller or the owner of the property responsible to give you that option at whatever moment in time the agreement allowed for. Bilateral contract, two or more persons, again, offers, purchase and sale agreements. Executory contracts. An executory contract is a contract that requires action to be taken until it's executed. A purchase and sale agreement is an executory contract where you are required to do certain things such as apply for your mortgage within a certain amount of time, close the deal within a certain amount of time, and maybe some other things. At the time that you go to closing and the deed is conveyed, which is also known as passing of papers, the contract is now known as executed. It is finalized. It is done. Assignment of contract. You can assign a contract as long as a contract has the ability to assign legally within it. You can turn over or assign a contract to anyone that's willing to accept it. There are two types of contracts that I want to explain to you. There is one called expressed contracts. An expressed contract is a contract that's in writing or verbal. The particulars are known and understood. Now remember, you will not win in court if you go in front of a judge and say, he or she was going to purchase my house and I have nothing in writing to prove that. You will not make it past that conversation. If it was in writing, yes. So express contracts are known or understood. An example could be, I have hired my neighbor's son to mow my lawn every week and I will pay them $25 a week to mow my lawn. I don't have it in writing. That is an express contract. If it was in writing, it would also be an express contract. If we had to go to small claims court because I did not pay my neighbor's son, that would be for a judge to decide who is telling the truth and who is not. Implied contracts. An implied contract is the conduct or the actions of each party. Example would be when you go into a restaurant, you ask for a table, they seat you. They give you a menu, you order your meal comes, and you pay. Nobody signed an agreement, nobody had a conversation about that before you sat in the restaurant and ordered your meal. So it's an implied contract. Your actions are implying that you will have a seat, you will get a menu, you will get a meal, and for that you will pay. Breaching contracts. In real estate, there are numerous ways that a contract can be breached. Default. Sometimes buyers will default on time is of the essence. If for some reason buyers and sellers aren't agreeing and we have a contract that needs to be canceled or voided and one party or the other doesn't want to do that, you could go to court and a judge could rescind that contract. You could also agree to rescind the contract. If a buyer and a seller go to closing and the seller decides at any point in time prior to closing or during the closing that they do not want to sell for whatever reason, there is a clause in your purchase and sale agreement that is called specific performance. Specific performance is when the law will side with the buyer and the seller will be forced to sell their property. They have very little opportunity to back out of a deal in a real estate transaction. One of the reasons that this is very important would be that a seller may have had a change of heart, a seller may have had a job change, or a seller sees that the equity in their home is increasing and they could have sold their property maybe weeks earlier or later or however timed out for much more money, and they want to back out in order to retain the equity. Liquidated damages. Liquidated damages are typically the remedy for the seller. They are a known penalty within the contracts that are signed. Your offer said you would put down $1,000 at the offer and maybe $20,000 at the time you sign the purchase and sale agreement. Well, if you, the buyer, default on your purchase and sale agreement and your promise to purchase the property, the known penalty to the seller would be your liquidated damages of the amount of money you put down as your down payment. So when you hear or see the word liquidated damages, think of that cup of coffee sitting next to you while you're listening to this. How much coffee is in there? And if you made a bet with your buddy and said, if I lose the bet, you get this coffee, they know exactly what they're going to get. So they know it's liquid damages. Compensatory and punitive damages are an unknown additional recovery of damages. Because you didn't purchase my home, not only will I keep the liquid damages or the amount of money in the purchase and sale agreement that we all agreed upon, I will also take you to court and try to recover on losses that were incurred because of the breach. I wasn't able to relocate. I lost money on the sale of my new home and other things that trickle down to make the matters worse. Those are known as compensatory or punitive damages. Forfeiture is just known as the breaching party, more than likely it's the buyer, will forfeit either all or a portion of their deposit because they did not honor the terms of the contract, known as default. This concludes Contracts in Real Estate, Massachusetts 12 Hours of Continuing Education modules. This module is about contracts in real estate. A contract is a voluntary agreement between two or more parties. Each one of them must perform a certain act within the contract. Contracts in real estate in Massachusetts fall under what is called the Statute of Frauds. In order for a real estate contract between a seller and a buyer in real estate to be valid and enforceable in a court of law, it is required to be in writing. Massachusetts law calls the requirement for a real estate contract to be in writing the Statute of Frauds. Oral contracts are not valid or enforceable. In the brokerage, we discussed listing agreements and buyer agreements. Those are considered contracts in real estate. An important contract in real estate is known as offer to purchase. This is a legally binding contract under McCarthy v. Tobin. Once all of the parties involved in an offer agree to it with signatures and a binding down payment check, you now have a binding offer. The offer has several contingencies within the offer. Think of an offer as a summary of what a buyer will do for a seller if the seller agrees to sell them their home. You would put together a summary of, I will pay this amount of money, I will put a deposit down of this amount of money within